When you walk into a child custody hearing, the judge is not going to ask whether you're a good dad. They're not going to ask about your home, your schedule, or your concerns. They'll start with one question only. And if you can't answer this question, this is over before you start. Forget it. You're dead in the water. Doesn't matter how good your child custody case might be. So I can help you with this. My name is Brent Boyer. I'm an attorney. I work here out of Metro Detroit, and we help dads, fathers just like you, deal with child custody issues all the time. And this one question that you have to be able to answer, the starting point of any child custody case, is what is the established custodial environment? What is the current established custodial environment, the ECE as they call it? So you have to feel ready for these custody hearings. You have to be ready. You have to gather all your documents. You've talked to friends, you've read articles, maybe watched dozens of videos, but there's one question that catches everybody by surprise. Is there an established custodial environment? Does your child have one? So what does this mean? What are they looking at? So most dads, of course, I've never even heard this term, but in Michigan, this singular legal concept can determine whether the judge will even listen to your arguments, whether they'll even listen to your custody case before it starts. You'll get nowhere without addressing this initial threshold beginning question. It's mandatory that the courts look at it before they do any change of custody and any reviews of custody and parenting time. So the first thing they ask is not who's the better parent or who has a nicer house or who's got the better plan. Instead, they start with this. Where does this child find consistency, stability, discipline, comfort, and guidance on a day-to-day basis? It's not about what your court order says. It's not about what your parenting time schedule should be. It's about your child's real life and their lived experience. Yeah, court order might be what you're doing. It might not be what you're following. If an established custodial environment does exist with the other parent, now you must prove that what you're requesting is in the child's best interest, and it's by clear and convincing evidence that you can prove proper cause change of circumstances to now change that established custodial environment. So whatever the routine has been, you're now asking for that routine that's in place, been in place for a long time, you're asking for that to change. A lot harder to do. The burden of proof is higher. Now you have to prove that by clear and convincing evidence. It's much tougher to do. You might walk into court ready to talk about the things your ex is doing wrong, the things that you're doing right, whatever it is, but the judge is not even going to be able to consider those issues unless you first clear the established custodial environment threshold, the ECE. Does your child look to you for the structure, the schedule in their life? Are you the one getting them ready for school? Who's tucking them in at night? Who takes them to the doctor? Who's helping with homework? Where does a child feel safe and supported? The answers to those questions is what's going to decide whether the ECE exists. And here's the catch. If your ex has the ECE in their favor, if it's established that they have physical custody of this child and you don't, then the burden of proof is on you. Now it's up to you, and your job is harder to prove that there's a reason to change this established custodial environment. How are judges deciding whether an established custodial environment exists? They look at facts, not accusations, behavior, not promises. They're looking at history, not just speculation. The types of real-world questions that a judge or referee might ask: who's handling the morning routine? Where does the child sleep most nights? Who meets with the teachers? Who takes the child to practice, to their extracurricular activities, doctor's appointments? Which home feels like it's the child's home base? Which one feels like their primary residence, so to speak? Where do they spend most of their time or most of their evenings? And has this routine been stable and consistent over time? If they've been living primarily with the mother of the child all this time, has that been going on for a while, or has it only been a couple months? Has it been a year? Has it been longer than a year? Then that becomes a big consideration. A court order does not automatically create an established custodial environment. You might be on a 50-50 schedule. You could have perfectly equal time on paper. But if your ex is the only one doing the day-to-day heavy lifting, doing the caring for the kids and taking them to their activities and handling things, and maybe you don't have that much time with them, or you're missing a lot of parenting time due to work or travel or conflict, the court might decide that the child is looking mainly to her for stability, and they may find that there's an established custodial environment in favor of the mother of the children, in favor of your ex. On the other hand, if both parents are sharing this ECE, when that happens, the same burden of proof applies before disrupting it. So if there's a shared custody arrangement and one of you is asking to change it, the law then is in favor of that shared custody arrangement continuing. So this next section, I want to talk about how an established custodial environment can change, how an ECE can change. ECEs are not necessarily permanent. They can shift over time. But, for example, if a parent moves away, or a parent stops exercising parenting time, or they violate the court order repeatedly, or they become inconsistent with the parenting time, unavailable, then the court may reevaluate where the child's stability truly lies. But here's the key. You must have the evidence. It can't be just suspicions, accusations. It can't be just my child told me this, told me that. There has to be some proof. School attendance record, missed parenting time exchanges, and proof of that. Sometimes just your word is the proof of the parenting time not being followed. If you've got dates and times and specifics, it's believable. The more specific, the more believable. You don't have to be able to prove it. Sometimes you can't prove it, but you're proving it by saying it, that it was so, and definitely that can be on your side and can be in your favor. And then this next section, I want to talk about how this works here locally in Metro Detroit, where we practice law. If your case is local here to Metro Detroit, Oakland County, Wayne County, Macomb, or even the outer counties, we handle all of that. And here in Michigan, these judges, referees that handle these child custody cases, they know the law. They know how to apply the ECE test. They're extremely cautious about what a child's routine is. They want to see well-organized evidence, what your commute is, your work schedule, your child's school district, how you juggle pickups and drop-offs. Definitely all of that matters. The father who's walking into court unprepared is going to get destroyed. And they can also run into the problem of not being able to bring this request again later. If you're trying to do a change of custody and it's done incorrectly, you can run into where we can't even help you with that later because you've already had your day in court, so to speak. So you want to be the father walking in with the structure, the timelines, and the documentation so that you're being heard. So next steps, if you're in a child custody dispute, you think you're about to be, here's what matters right now. Document your involvement. You have to document things best you can. Keep school records, medical records, calendars, texts, logs, whatever it is that's going to prove what's been going on, what the schedule is, what your day-to-day role with the children has been. Make sure you can establish a timeline, prove your timeline. The judges care about long-term patterns, not one weird month of she let me take the kid a lot because she was out of town or something. Those things won't matter. And don't rush into filing this with the court. Filing with the court is the last thing you want to do. After you've looked at all of it, a poorly timed motion can be dismissed immediately if you can't clear this initial ECE hurdle. So talk to a lawyer, get advice about child custody, custodial environments. Make sure you're getting the right advice. It's not something you want to be trying to figure out on your own. If you're a father in Michigan looking for help with this, we can help. Website is adamdivorcelaw.com, or just give us a call. Of course, numbers on the screen, and hopefully that helps. And if you're looking for some next steps or just some more information about this, you can certainly contact us, or you could watch the next video here. We'll have a child custody video in the end here. Take a look at that and get in touch with us. Hope that helps.